Please rise. This court is now in session.
I'm sorry, Liam. Please be seated.
Three 24-0494. Juan Jaime, appellant by John Urban versus Shabir Nomenboy, appellate by David Smith.
All right, Mr. Urban, you may proceed.
Thank you, Your Honor. My name is John Urban. I'm an attorney in Wilmington, Illinois, and I represent the appellant, Mr. Juan Jaime. This is the second time that this case and these parties have been before this court. First time it was before the court. The court vacated the judgment against my client in the amount of $917,000 in fraud for damages. And the court remanded the case for further proceedings. This court gave instructions to the trial court in regards to how it should handle the case on remand, and instructed the trial court to make specific findings as to the appropriate amount of contract damages for rent, additional rent, holdover rent, and late fees. It's also some security deposits at issue. In regards to items concerning fraud, this appellate court sent it back to the trial court to determine for this court to evaluate the proper amount of damages for the fraud issues. And the court instructed the trial court to consider funds actually received by plaintiff Juan Jaime from sublessees. This was a strip center that Juan Jaime had conveyed to the defendant Nomenboy with the plan to acquire the property back within 12-15 months. There was a contract entered into to do that. However, it was alleged by Mr. Nomenboy that Juan Jaime violated the conditions of the option agreement and other agreements in regards to rent. Juan Jaime had two corporations that he owned that were renting space at the strip center, totaling about 56% of the strip center. And the allegation was that against the written contract, Juan Jaime subleased the property, two of the units that Juan Jaime's corporations owned. And according to the contract that was drafted by Nomenboy, that Juan Jaime was prohibited from subleasing it. And if he did sublease it, it had to be, any rent had to be turned over to Mr. Nomenboy. So it was alleged that that took place, and he leased it and didn't turn it over. So it went back to the trial court, of course, and at the trial court, no new evidence was taken upon remand. The parties argued as to the proper amount of damages for contract and for the fraud damages. At the trial itself, before it went to the trial court the first time, the defendant claimed that he was owed certain amounts of money for rent, additional rent, holdover rent, and late fees. The amount that he claimed was owed for those items by one of the corporations called La Hacienda was the amount of $57,000 and some dollars and cents, but $57,000 was owed. This is what, no one testified was owed him. And that's the amount that went on appeal to the appellate court. After it gone to the appellate court, and it was remanded back, the Nolan boy did not argue exhibit 110A, which was a demonstrative exhibit, because that's the exhibit of which Mr. Nolan boy testified the money was owed. But instead chose an exhibit 110. Exhibit 110 was never admitted into evidence. The numbers that Mr. Nolan boy wants to use to show damages are not exactly the same as the ones on 110A. And it's our contention that 110 should not have been used to determine what the damages were in this particular case. And it was based upon that, it's our contention that the judgment of the trial court was basically without basis in the evidence, because the trial court relied upon an exhibit 110, which was never in evidence. Reviewed the judgment order of the trial court that determined that the judgment against La Hacienda was in the nature of about $435,000. Maybe more than that. 569. I believe about $350,000. And because of that, trial court should not have used exhibit 110. Actually, there's two exhibits 110. There's another one. The other 110 was for 6 months of 2018, like 110A was. But the one chosen by Nolan boy to establish his case for damages was only for 3 months of 2018. So now the exhibit Mr. Nolan boy chose for damages was exhibit 110 for only 3 months. This exhibit did not include late fees. It only showed additional rent, and holdover rent, left out late fees. The other exhibit 110 and 110A all included late fees in the calculations of what was owed. So I believe the defendant, Nolan boy, believed that he could insert his own new version of late fees into this in order to raise the amount of the judgment from a possibility of $57,000 up to $435,000. It should be interesting that the exhibit 110A that was utilized at the trial all indicated that there was late fees due and owing, and it was calculated at the basis of $50 per late payment. Wasn't based on a 5% recurring interest rate. So it's our contention that this involves in compounding, and under the case law, under 3rd District, going all the way back to at least 2001, in regards to the one case that I cited, and actually there's two now, you cannot keep charging an interest rate on the same non-payment month after month after month. You can only charge a one-time charge. That's not what the defendant in this case has done. They charge 5% each month. Not only that.
Quick question, Mr. Urban. You're saying he did that on remand. At the trial, his exhibit his exhibit was 110A that just asked for the $50, the $50 late fee, which came to like $3,600.
Correct.
Okay.
So there's lots of other items in here in regards to his damage claims that are incorrect in regards to the amount of additional rent owing. The contract itself was amended by an addendum, which provides that the only charges for additional rent would be taxes, real estate taxes, and insurance. But in some of these years, Mr. Nolan has included other charges, which should not be allowed because it's not in the contract. Additionally, contract, I believe, language shows that the interest should be the taxes rather start in the year 2014. You do not start paying 2013 taxes once you start renting a parcel of property in late May of 2014. I think that's rather unheard of that you be stuck with that. And that language of the contract, the addendum does not show that. Contract shows when you read it as a whole that 2013 is used as a reference to establish that the 2014 taxes is the current year. And in the current year, 2014, you will base the 2014 taxes that the plaintiff is required to pay on a monthly basis, divided, into 12, based upon the previous year's 2013 taxes. So that's the reason why the 2013 is there. And it's probably put there because of the fact that prior to this addendum being signed, and it's all in the record, the defendant had gone to the supervisor of assessments office and gotten a substantial reduction in the assessed value of the property, meaning that the actual taxes that were going to be due for 2014 payable in 2015 were going to be substantially less. So I believe Mr. Nolan Boyd wanted to freeze the amount that was going to be paid in 2015 or 2014 taxes, not based upon the assessment, but rather on the prior year's taxes, which were at a higher rate. So, I know there's quite a bit of language in the Nolan Boyd's brief that states that no, 2013 was supposed to be included. That I don't believe that's clear at all under the addendum. And at the trial of the case, the defendant, Nolan Boyd, actually testified. He agreed that the way that the addendum is written, he was not supposed to charge taxes for 2013, but he did. So that should not be allowed. And he testified that those tenants should be given a reduction for that year off of the amounts that they had paid. That amount was $19,040. So any sort of judgment and damages for contract damages should be reduced by at least that amount. I filed memoranda and other items in regards to this with the court to bring out these issues, but it was never ruled upon. So the case cited by the appellant, Perfection Corp versus Lock and Bar Corporation, states that it's incumbent upon the person who seeks damages. They have the burden to establish that they sustain, not only that they sustain damages, but they have to establish a reasonable basis for the computation of damages. I don't believe that you can reasonably compute damages that you suffer by including items that you're not entitled to include. And that's what was done here. In the document submitted to the trial court, like I said, was never reviewed or ruled upon. I included methods of determining how much money was either due or not due from Juan Jaime. And that was never, ruled upon. So once again, a lot of what happened in the, a lot of what the appellate court ruled upon was not followed. Trial court, and a lot of it had to do with the defendant submitting this exhibit 110, which is not evidence, it's not admitted, and a lot of the sites placed in the brief of the appellate, the sites are not correct. So they cite to other things, or they cite to items that are not admitted. So I know I have that contained in my brief.
I do not.
Mr. Urban, thank you very much. You will have an opportunity in rebuttal.
Thank you.
Mr. Smith.
Thank you, Tom. May it please the court. I am David Smith. I represent the appellate, Sugar Noman Boy, in the case before you today. A couple of things that I would like to address in my panel. First, as a preliminary matter, and counsel had mentioned it, excuse me, recently, that counsel had mentioned specifically at page 10 of his reply brief, and I appreciate him bringing this up. That certain citations contained on pages 30 and 31 of the response file that we have contain citations to a document that was not admitted as evidence. The record will reflect in the citations contained on those pages are citations to trial exhibit 57. So, which is located at C3736. The record also reflects that there was an exhibit 58, which is located at C3745. 57 and 58 were duplicates of the same email chain. So 57 was an email chain from June 18th of 2014. 58 also was that same email chain for two duplicates. On August 2nd of 2018, the trial court entered an order which is located at C2087, which indicated that the exhibit summary, attached the exhibit summary submitted by the parties, and stated that the exhibits were admitted as stated on that summary. Exhibit 58, which is a duplicate of 57, was in fact admitted. In other words, quite candidly, counsel is correct. I cited the 57, which is a duplicate of 58, which was admitted to evidence. Again, I do have those citations. So just so the panel is aware, the emails that were cited to were admitted into evidence, but they were admitted as exhibit 58, not 57. So I just wanted to make sure that the panel was aware of that. More generally, as counsel had addressed, and obviously as the court is aware, the case was remanded ultimately for a determination of damages. In the court, excuse me, and its remand order instructed the trial court to make determinations based on breach of contract, including the amounts of base rent, additional rent, holdover rent, and late fees due, as well as the security deposits to be returned. And with respect to fraud, the trial court was instructed to take into account the amounts that Jaime paid, or what received, I'm sorry, versus the amounts that Jaime paid to Mr. Noman Boyd during the relevant time period in question.
Mr. Smith, can I ask you to
Yes.
address directly the late fees on remand as it relates to Hidden Grove and Mulfata?
Yes, Your Honor. So, as I stated in the brief, first of all, counsel is correct. Exhibit 110A, which was admitted at trial, did include, I believe it was $50 a month. That's first and foremost, that is accurate. As argued in the brief, unlike in Mafado, the late fees sought were not compounded. The lease provides that 5% per month of the outstanding amount shall be charged, and ultimately the amount that was charged by the trial court was 5% per month of the outstanding balance. In other words, it didn't compound as was argued in Mafado, but that amount was charged successively. In Mafado, the court, Your Honor, had indicated that a 5 to 10% charge is standard. So I think that the 5% listed in the lease is appropriate. The lease on its face states that that amount shall be charged monthly, and that was the interpretation that the trial court ultimately enforced. So 5 to 10% is acknowledged in Mafado as a standard rate. Some of the other cases I cited in my brief, Collins and Tadros, likewise, talk about 2% per month, 12% per month. And in light of that, I believe that the trial court's assessment was correct. Alternatively, as I stated in my brief, and again, strictly the alternative, should the court find that 5% per month constitutes a unenforceable penalty, I would ask that the panel still enforce a flat 5% charge, as the court did in Mafado. And now, with respect to damages specifically, as the court's aware, the determination of damages won't be set aside unless it's manifestly erroneous. Absolute certainty is required, but only on an adequate basis in the record. And I would submit to the panel that the judgment amounts that were awarded by the trial court, are supported by the record. With respect to the fraud damages that were awarded, the trial court ultimately found that the amounts paid by one of the tenants, Shalash, did not exceed the amounts that Jaime ultimately paid to Noman Boyce. The trial court did not award any damages with respect to that particular property. With respect to, La Hacienda, the La Hacienda property, which is Supermercado property and La Hacienda property. With respect to the La Hacienda property, the trial court ultimately determined that a total of $198,000 was received in rent between the tenants identified as Jasso and Duff. The trial court's basis for imputing or finding that 120,000 of that was paid by Jasso was effectively the lease that Jasso has executed was in June of 2014. He stayed in the property for approximately 20 months, and that conclusion is likewise supported by Amber Duffy's testimony that cited in the brief as well. And the court imputed that Jasso made those payments during that time period. Now, I recognize that counsel raised this in his brief. Counsel is correct that the only, I guess I'll say, direct evidence as to what Jasso paid is Mr. Jaime's testimony that he received approximately $36,000 from Jasso. Again, I remind the court that the trial court very poignantly found that Mr. Jaime was, quote, not at all credible. So I think that the trial court was within its discretion to disregard that testimony, and based upon the facts and circumstances before it, draw the inference that the rent, during this time period was paid. With respect to Duffy, Ms. Duffy did testify at trial, and she did testify that when she moved in February of 2016, she paid $13,000, And the lease required that monthly rent of $6,500 be paid, as well as a security deposit, I believe was approximately $26,000, but there was an initial payment toward that deposit required of $6,500. So in essence, her lease said that upon move-in, she had to pay for February, and she also had to make an initial $6,500 payment toward her deposit. She testified that she made that payment, the amount of $13,000. Excuse me. And then she also testified that she paid for 11 months worth of rent. So based on the testimony that was, and then she also testified as well that on January 21st or 2nd, I believe was both of the testimony. Ultimately the locks were changed. She stopped occupying the property. So based upon the testimony that Ms. Duffy gave with respect to what the trial court determined she paid, I think that is well supported by the evidence that was presented. We effectively have a lease that says $13,000 is due on the front end. Ms. Duffy made that payment. Ms. Duffy also testified that she paid for 11 months worth of rent. 11 months would take us from February through December. She did not pay in January. There was a situation where she ultimately did not have possession of the property anymore at the end of January. The point is that testimony, I think, is, or I'm sorry, that $78,000 that the trial court found that Duffy had paid, excuse me, I think is well supported by Ms. Duffy's direct testimony. And so I don't think that the trial court abused its discretion or otherwise entered a manifestly erroneous judgment by determining that total of $198,000 was paid during the time period between Jaslyn and Duffy. And as stated in my briefing on the trial court's judgment, a total of $111,964 was paid by Mr. Jaime during that period. The difference was ultimately the amount that was assessed under the fraud count by the trial court. With respect to the contract damages, in evidence for Exhibit 110, which 110A, which is included in the appendix of appellant's brief, as well as 127A, which provided the underlying calculations that Mr. Woodward had made with respect to common area maintenance charges, taxes, insurance, and things of that nature. Again, the trial court found that Mr. Nomenboy was credible, and the trial court therefore was within its discretion to take those exhibits and that evidence at face value effectively. Excuse me, use those numbers in determining the contractual amount to be assessed. And counsel is correct that in connection with certain arguments and things of that nature, a non-admitted exhibit 110 was attached for demonstrative purposes only. And I think a review of 110A and the 110 that was submitted for demonstrative purposes only will show that while there are very slight differences in the amounts listed as due and paid and what the shortages are, those are not at best. And ultimately, and I've got the math here, I don't want to go through every single line item, but at the end of the day, looking at the two next to each other, the numbers are almost identical. And quite candidly, the purpose for, in part at least for using that 110 in conjunction with 110A was to demonstrate what had been paid through March for purposes of ultimately determining liability for the loss in this space through March of 2019, which I'll get to momentarily. But I would also point out that the trial court, in connection with counsel's motion to reconsider, likewise ultimately ruled that I believe the exact language was the existence or non-existence of 110 makes no difference to the court's conclusions. And I think that is reflected by the fact that 110A and 110, again, the numbers are almost exactly identical. So With respect to, one thing I did, and I know, I'm running a little low on time here, but one thing I did want to address, was, the issue of the taxes. I don't believe that the lease language in the contract documents make clear that 2013, the amount paid in 2013 was not due. Counsel's position is that taxes, the tax bill for 2014 due in 2015 was ultimately what was supposed to be paid. I don't think the evidence supports that. Again, going back to the preliminary issue I addressed at the beginning of the argument, the emails between the parties, as well as the language of the documents themselves, are not clear, and I think it shows quite conclusively that it was intended that Mr. Noman would be compensated for the amounts that he in fact paid in 2013. Counsel mentioned in his argument that it is not common for that to occur, but I think that the record reflects as well that this transaction was certainly anything but common. I recognize that. I recognize in an arm's length, just a commercial landlord and tenant transaction. Yes, that may be commonly what is done, but this was not that. This was a very complex series of transactions and occurrences that ultimately led up to the contract between the parties. So I see my time is up.
Are you serious? I do not.
Mr. Smith, thank you very much.
Thank you very much.
Mr. Urban, rebuttal.
For the fraud claim for damages, the instruction to the trial court was directed to funds actually received. The only testimony was it was 36,000. There was no other testimony that anything else was received other than 36,000 from Hasso to Jaime. The use of the lease to establish that something was paid, that's a brand new novel theory to me. People, going to court, well, I had this lease and I paid or I didn't pay. Without any other evidence. It's sheer conjecture, it's speculation that it was paid. In this particular case, in the first matter before the appellate court, the facts of the case in regarding to Shalash established that Shalash remained in the parcel, the property, for a number of months and didn't pay anybody. That was established, and then he left. So that was not attributed to Jaime. So simple fact that, well, there's no eviction on file to show that he was evicted doesn't establish that Hasso was there paying rent. Hasso could have left. There could have been no one there. There was no one there. How does he file an eviction? Additionally, in regards to this claim for security deposits or the security deposit, well, Duffy paid a security deposit because it's in the contract. There's nothing in the testimony of Duffy to establish that she paid a security deposit. She thought that the 13,000 she paid was rent and base rent. It wasn't a security deposit, but her testimony was such that total amount she paid was what she paid, and it wasn't enough to cover a security deposit. Same thing with Hasso. There's a claim that, well, his contract required a security deposit. There's nothing to show that that security deposit was paid. There's nothing there to show that it wasn't, or if you did pay it, that it wasn't repaid to him. There's nothing in the contract. So it's just sheer speculation and conjecture that it was paid. This is a fraud matter, so the court said you have to establish proof of your damage, and it's not there. In regards to Muff et al., actually what the landlord in that case wanted to have 5% each month. And the trial court only allowed 5%, one-time charge of 5%. Meaning that you're late 1 month, you get hit with a 5% charge. The next month, you don't get hit with another 5% for that prior month. It's just 5%. It was a 10-month time where the rent was not paid. And the amount of the late fees incurred, if you look at it, was only, it comes out to 5% as a one-time charge per month, just like in the case in 2001. It just escapes me at the moment, I'm sorry. Willow Grove, I think. So that's the issue there. The extrapolation, there's more to it than simply, I'm gonna extrapolate how much he paid each month, and then we'll figure out what's going on. Extrapolation in regards to the amount that's due and owing. Also, it's not just what's paid, it's the items that go into the expenses. Each year, taxes may go up or down, same thing with insurance and other charges, so you can't extrapolate it. I could not find any case that says you can extrapolate a contract case. I think what that means, what you're dealing with, simply conjecture and speculation again. And that should, that's absurd. At least hitting growth. Thank you very much. Welcome to answer any questions.
I do not.
Court thanks both sides for spirited argument. We will take the matter under advisement and render a decision in due course. Court is adjourned until the next argument. Thank you.
As stated.
Yeah.
Yeah, that's good. There are some. Stays up there, you know, over, we need to raise the temperature, summer's gone for a month. 6 8 there, they start. I don't think this is because. Line and a half, maybe that's. Does it really? A little bigger. Here. I know what I'm gonna like that. It's not too bad. Oh, thanks for coming. I'll make it, that'll be a lot, that was information. So, I think that'll be. So she. Reason for that. I don't know. Shortly after both of them. Told the boss, or told everyone, he showed on 60 minutes, all of a sudden, he was a region was. So the president talks to me and says, they went to some big was what? And I said, they would stay on the upstairs. So they would come today. But come on, like it's oh, no. Yeah, we are, and actually, we have to start with it's sad. We stop, like, the rest just start. That's right. We're just like, stay here. It feels like we just got confused with everybody. You like your boss that. Yeah. Just like you don't time. It's like it's kind that's what I need to do is get started. Court is now in session.
Please be seated. Thank you. Will the clerk please call the next case?
0575, the people of the state of Illinois, appellate by Justin Nicolosi versus Tacky J. Evans, appellant by Omar J.L.
Counsel, you may proceed.
Mr. Nicolosi, honorable justices, may it please the court. My name is Omar Jalil, and I represent the appellant Taki Evans, who seeks a reversal of his felony domestic battery conviction based on the ineffective assistance of his trial counsel. His trial counsel was ineffective for two reasons. The first reason was because trial counsel introduced defendant's exhibit number 1, which was a photo depicting a prior incident of domestic battery that involved Mr. Evans, Ms. Gonzalez, who is the victim in the charged offense. That uncharged offense, there was no reason for trial counsel to admit defendant's exhibit number 1. The decision was unreasonable. No rational attorney would have admitted defendant's exhibit number 1 into evidence. This decision allowed the state's attorney's office to argue that Mr. Evans had a propensity to commit domestic battery. And that was done without proper judicial findings that's required by section 115-7-7.4. And it also allowed the state to argue and to explain the reasons why Ms. Gonzalez didn't call the police as a result of this alleged incident. Additionally, this decision cannot be regarded as a trial strategy. The central issue at court, at the trial, was Ms. Gonzalez's credibility. And the introduction of defendant's exhibit number 1 did nothing to attack her credibility. All it was used for was to show that Mr. Evans had a propensity to strike Mrs. Gonzalez. And again, the highlight of this is what's greatly prejudicial of how soon this prior incident occurred. It was within a month. Ms. Gonzalez testified that it was at most a few weeks old. And then second, trial counsel was ineffective based upon his decision not to seek a lesser included instruction. That decision also cannot be regarded as trial strategy when it was based upon a misapprehension of law. The trial judge asked trial counsel whether there were any other included offenses. And in response to that, trial counsel stated, "No, Your Honor, there are no lesser included offenses." This statement was patently misdemeanor domestic battery is lesser included offense of aggravated battery. That's a point that the state has not contested in their responsive filings. And the fact that trial counsel made this statement to the trial court takes it out of the world of trial strategy when it's solely based upon him not knowing that a misdemeanor domestic battery is also a lesser included offense of aggravated battery. And finally, the state has argued that these issues don't matter because the prejudice that Mr. Evans hasn't suffered any prejudice as a result of trial counsel's error. Sole purpose of preventing other crimes evidence is because it proves too much. And the prejudice that Mr. Evans suffered as a result of this is immeasurable. This was a case where the victim testified to an unprovoked attack that was then used by the state to argue that Mr. Evans had a propensity to commit domestic battery. And the prejudice he suffered as a result of that deserves a new trial. And
How do you apply Strickland to this case?
well, I mean, so I would say that the error occurred and that but for this error, the reasonable outcome of the trial would have been different. As to the second issue, whether a lesser included offense of misdemeanor battery should have been granted, that was really the only evidence that the state presented is Mr. Evans's admission in the jail recording that he had slapped Mrs. Gonzalez. The evidence related to the strangulation was inconsistent. It was contradictory. The jury showed that they had some issues with it based on their questions. And the way
And what were the questions?
they asked,
They asked questions in the jury.
they did ask
Yes,
questions.
yes.
And then how,
Which questions did they ask?
one of the questions that they asked, Your Honor, was how certain is reasonable doubt percentage? That was responded, and then they also asked for a definition. The trial judge,
Definition of what?
reasonable doubt.
Okay,
The trial judge, appropriately responded by telling the jury that they had all the instructions to continue to deliberate. But that statement shows that there was an issue with the state's evidence. It wasn't, a slam dunk case. And a lot of it had to do with how inconsistent Mrs. Gonzalez's testimony was with the officer's testimony and Ms. Courtney Cohen's testimony. The officers responded to this scene as it was just a regular domestic battery situation. They didn't take any witness statements. They didn't take any photographs of Ms. Gonzalez.
What do you mean by a regular domestic battery situation?
Well, what I mean by that is the officers testified that domestic battery was their number one call that they were called out on. So I'm not trying to downplay the severity of a domestic battery call. What I'm trying to highlight is that this was a call they went on all the time. And they had a frequency, a familiarity of how to handle these types of routine, quote unquote, bad word for choice, but routine domestic battery calls. Versus a class 2 felony where the victim has claimed that she essentially has been choked to near death, that she was choked for 30 seconds. But when they arrive, they don't see evidence that's consistent with that. They see evidence that's consistent with her being possibly slapped. Her eyes are puffy, her red side of her face is puffy, and then there's slight markings on her neck. But those slight markings aren't consistent with having been strangled to the point where the victim testified that she couldn't see or she couldn't see anymore, that she was getting dizzy, that she was seeing stars, that she testified that it lasted for 30 seconds. The police officers, when they arrived, didn't treat it that in a situation where somebody had just been strangled to virtual death here. They didn't take her to the hospital. They didn't take any photographs of her. They didn't take any statements of Courtney Cohen, even though she admitted that for the police that she was on the phone when this occurred. And how she described the incident is just inconsistent with Ms. Cohen's testimony as well. How she described it, that Ms. Gonzalez testified that she was victimized by 2 separate choking incidents. And in between these incidents, she made a phone call on a FaceTime to Ms. Cohen. But Ms. Cohen testifies that she's seen essentially the first one when they're on the ground. And how she's testifying to it just doesn't add up to Mrs. Gonzalez's testimony. In addition, Ms. Gonzalez testified that after this occurred, she ran into the laundry room and locked herself in there. But that's not what the police officers testified to. The police officers testified that when they arrived, she's the one that answered the door, which can't have, both of those can't be true at the same time.
And when you say she, you're referring to the victim.
Ms. Gonzalez, yes.
And this FaceTime call that was placed, there's no evidence of that. There's no recording. There's no digital recording of that at all. That was ever introduced into evidence, correct?
You're right, Your Honor.
Thank you.
Your Honor, based upon the reasons stated here, and in Mr. Evans's opening brief and his responsive brief, we respectfully request that Your Honor enter an order that reverses the conviction for felony domestic battery and remands the matter for a new trial.
questions?
On both counts? I mean, on aggravated and potentially a lesser included, just send it back.
Just send it now.
Okay. Obviously, there was no second counts.
Thank you, Your Honor.
Any further questions?
No, I have no further.
Oh, okay, counsel, you may be seated.
Thank you,
Thank
Your
you.
Honor.
You'll have time and reply.
Thank you.
Counsel, you may respond.
Thank you. Good afternoon, Your Honors. May I please the court, Mr. DeLeo. My name is Justin Nicolosi. I represent the state of Illinois in this matter. I'm sure the court is aware, but I was not the attorney who wrote the brief in this case for the state, but I'm arguing here.
So please take it easy on me with your questions. I'll try my best to answer them. The state submits that the defense counsel was not ineffective in this case. Regarding issue one, a photo of the slap from about a month prior to the current incident. We don't need to speculate why the defense attorney presented this evidence for the jury. He explained both during trial and during closing why he wanted this piece of evidence. That the picture, I looked at the picture of the slap, there's the hand mark on there. He explained that he wanted this to kind of show the dichotomy versus of that injury, which was kind of a definitive slap in the picture versus the pictures that were taken after the alleged choking and slapping in this case. Again, counsel isn't required to be a perfect attorney. On the surface, I could understand why a defendant might think that was an odd move, but again, we don't have to guess on this case. Counsel said if this victim was choked, as she contended to police and at trial, there would be more definitive marks of the defendant's hands on her neck, like there was on her thigh.
In this case, as opposed to other cases cited in the brief, and I do recognize that you didn't write the brief. Yeah, I forgot the question because of that. It'll come back to me.
So anyway, that's why counsel went forward with this particular strategy, and the state submits that's a reasonable strategy. Again, this evidence, contrary to what Mr. Jalil argued, the state.
I remember the question.
Oh, yes, Your Honor.
In this case, as opposed to the ones that some of them cited in the brief, the ones cited in the brief, there was a definitive acknowledgement by the defendant that he or she had agreed to the particular tactic.
Yes.
Is there any evidence in a record of this, and does that make any difference?
Your Honor, there's no evidence that the defendant actually consented to that particular strategy, and the case was Bell that my colleague cited. No, there is no. This case, of course, is different in that regard to Bell, as Mr. Jalil pointed out in his reply brief. The part of Bell that I think Ms. Theodoratos, who wrote this brief, was referring to is the strategy of presenting a photo in order to kind of undercut some of the state's evidence. That's what happened in Bell, and even though that wasn't the basis for Bell's ultimate holding, it did in dictum discuss the strategy aspect of that case, and did find that it was reasonable strategy to present that photo. We would argue that it's reasonable strategy here. Again, looking at this case, I don't know what else the defense counsel could have done. I'm going to kind of transition over the prejudice to talk about the evidence in this case. State submits there's no real reasonable probability that the result of this trial would have been different if the defense counsel would not have presented that photo. Michaela presented pretty strong testimony of what the defendant did to her. 2 incidents of choking.
If I could ask, in moving to reasonable probability, are you conceding error?
No.
In the second prong?
So the second prong.
I mean, with regard to, okay, so you're gonna move on to that?
We can actually discuss counsel's performance regarding the second issue, and then I can get to prejudice at the end. If that's what Mr. Jalil did, I can certainly do that too. So issue 2, I'm going to kind of get out in front of it. As Mr. Jalil argued in his reply brief, I don't know if my colleague who wrote issue 2 responded to the question that was posed by the defendant. The issue was whether or not counsel's decision regarding the lesser included instruction was that decision was based on misapprehension of law. We didn't argue that in our brief. I understand that would foreclose me from arguing that in oral argument. I understand also that the court is not bound by waiver, that the court can reach the issue if they so choose. I just wanted to point out that I don't think the evidence on that issue regarding the fact that the counsel said there are no lesser included offenses. I don't know if that's as definitive as the defendant is arguing here, whether, you know, that counsel actually believed that there were no lesser included offenses. I can't imagine for a second that this defense attorney thought that there were no lesser included offenses.
Well, wouldn't that demonstrate his incompetence?
No, Your Honor, I think this is an issue where, again, if the court would allow me to keep talking about.
Oh, sure.
Fight our potential waiver of this. This is an issue I think that we need to hear more from defense counsel. I feel like if I had to guess what the defense counsel was saying is that we talked about it because the question that the court posed was, did you talk to your client about lesser included? Counsel said, yes, I did. There are no lesser included offenses or something, so please don't quote me on the verbiage of that.
That's pretty darn close.
I think it's pretty close, but what I think he's saying is that we're not offering any lesser included offenses at this time. I think because he said he talked to the defendant about it, and I think that's the only rational conclusion. I don't think he's saying there are no lesser included. Again, I don't think that would be incredibly incompetent.
And that's because domestic battery, at least in this situation, is always a
Of course, that's.
lesser included.
Yeah, so again, I think this court can't decide based on this record, what what defense counsel was thinking, just based on that particular sense that he offered to the trial court.
So we can't tell definitively whether he was saying, we aren't offering any lesser included, or whether he was so idiotic as to not know that there was a lesser included.
I don't think so, Your Honor. I think, I can't possibly think that the defendant was the defense counsel was this, ignorant of the law to have made that statement. I feel like there has to be more to what he was saying or was trying to say. That
So your position is he was just saying, we're not offering any other.
I'm saying, that's my guess as to what he was saying.
Or
because
the,
I have
or
to
the
give-
author of your brief's position.
Well, the offer of the brief didn't mention that at all.
Okay.
They went a totally different direction on what they argued.
Okay.
I'm just saying, I have to give this defense attorney a bit of credit as to not being completely, you know, with knowledge of the law, that he would say there's no lesser included. I mean, I think this is kind of a Veach case where you need to hear from defense counsel a little bit more before you can make that determination, because taking that sentence for what it is and running with it, I think is giving this attorney zero credit, and I think the attorney should be given a little bit of credit for that. But anyway, so that's where I stand on issue 2. But regarding prejudice for both of these ineffective assistance issues, the state is going to argue that there is no prejudice to the defendant. No reasonable probability of a difference.
The evidence not closely balanced.
I don't believe so, Your Honor. Michaela Gonzalez testified regarding the injuries she sustained. There's the defendant's phone call in the jail.
All he admitted to was a misdemeanor though, didn't he?
Sure, but he still certainly admitted that there was physical confrontation.
Sure.
Certainly on his part, so there's no injuries on him, so it's probably a one-way dispute here. She had the pictures of her injuries, that was exhibits, or that was pages 9, 10, 11 of the exhibit file. We saw her neck, it was very red. Whether or not there were finger marks on there, I think we can all agree that her neck was very red, which certainly supports her claim that she was choked. We have Courtney Cohn, who received a FaceTime call from Ms. Gonzalez during the incident. She couldn't see everything because of the angles of the phone, but she saw the defendant push Ms. Gonzalez. She saw the defendant on top of him with his hands around her.
She saw him choke her twice when the first choke happened before the phone call though.
Well, I think
Would that not suggest that she talked to somebody in between?
I don't know what to make of that. That's kind of a difference in the case or the evidence, but I don't think a couple of inconsistencies in the evidence renders this not a close case. I think it's not a close case at all. I think I misspoke there, but I'm gonna say this isn't a close case at all, Your Honor. Anyways, we have Courtney supporting Michaela's testimony in that regard. Of course, we have the officers who arrived. They heard angry yelling from the male inside. The male answered the door. She was obviously upset. She was scared, fearful. That supports the fact that something pretty terrible happened in that house, that residence. And again, the photos of Michaela's neck were, I think, pretty strong evidence that there was some strangulation that she alleged. So based on all that evidence, I don't think the photo of Ms. Gonzalez's thigh from a month earlier, it would change the outcome in this case in any material respect. And for that, I would argue that that defendant has not been able to establish prejudice in the Strickland analysis. So the state would request this court to affirm the defendant's aggravated domestic battery conviction. Are there any other questions that you have to answer?
I have one, and I know it's not your brief, but the person who wrote the brief cited the BALLE case for the proposition that a lesser included is typically strategy having no no impact on the ineffective assistance or competency of counsel. Now, that case involved a class 2, and I think another felony would have been the lesser included.
Okay.
Does it change it in your mind that the lesser included here, or does it matter whether the lesser included here is a misdemeanor, therefore the risk that much less? Because one, if you had the lesser included, it would, an all or nothing, the lesser included would be a felony, and here, an all or nothing, the lesser included would be a misdemeanor with significantly less consequences, not only jail, but stigma and job opportunities, the whole shot.
I understand that, Your Honor. That's a reasonable consideration, but I think what we're talking about in this case, I think the fact that the evidence of the misdemeanor, the underlying offense, was so certain in this case. I think that the one issue that I think there was maybe a little bit of dispute on was whether or not there was strangulation, and that was, of course, was the aggravating factor. I think it was reasonable to focus on that particular element, because I think it was a guarantee that if they presented the lesser included domestic battery, that would have resulted in a conviction either way, regardless. And so I think it was a reasonable strategy. You should try an all or nothing approach. There's a lot of cases that support the all or nothing approach. I understand the felony.
Yeah, most of those are in the murder, second degree type things like that.
Sure, yeah, this is a little bit like you said. I have to acknowledge there's a difference between the felony and the misdemeanor, of course. But if we're just talking about trying to have his client acquitted completely, I think this is a reasonable strategy.
Thank you, sir.
Thank you.
Thank you, counsel. Counsel, you may
Thank you.
reply.
May I proceed, Your Honor?
Oh, yes, please. Thank you.
Your Honor, in regards to the conversation that trial counsel had with the trial judge, the trial judge asked whether he had talked to Mr. Evans, and I quote, about any other type of offenses that may be considered lesser included, end quote. Trial counsel responded, quote, yes, Judge, I don't believe there are any lesser included, end quote. That statement clearly shows that trial counsel was wrong on the law. There's nothing else that can be read other than, I don't believe there are any lesser included, that he didn't believe that a misdemeanor offense was a lesser included in this. The conversation was directly about lesser included offenses.
So what was the question again from the court?
Whether he had talked with Mr. Evans, quote, about any type of other offenses that may be considered lesser included, end quote.
Okay,
And his response was, yes, Judge, I don't believe there are any lesser included.
okay, so really plain language analysis would be, yes, I did talk to him, but I believe that the counsel believes there are none.
Absolutely, Your Honor.
Okay,
And there was no further comment after that.
There was no further comment
Thank
after that. And responding to Justice Bertani's question,
well,
whether.
let's say he didn't want a lesser included, okay, because of strategy, which was been proposed today as a possibility. Okay, well, how would counsel frame that answer
Well,
if asked by the court?
I think the issue would be that the nature of that conversation. That conversation between trial counsel and Mr. Evans would be, if Mr. Evans is the one that approached this, or whether trial counsel brought it up, but the only logical thing would be in this situation that Mr. Evans would have had to approach it, because trial counsel's opinion is that there are no lesser. So he wouldn't be having conversations with Mr.
Well,
Evans.
no. We're talking about the conversation between the court and defense counsel. Right, because defense counsel said, yes, which would mean presumably, yes, I've talked to my client.
Correct, Your Honor.
And then a comma, I don't believe, which goes to arguably his knowledge. And so if you're gonna try to suggest this is trial strategy, or I mean, to make the claim that it's trial strategy, I think that's what's opposing counsel is trying to say. Correct me if I'm wrong.
I believe that's correct.
Okay. And if you were the defense counsel, this exact situation, and you wanted to go all broke, all or nothing, would you have said to the court, I don't believe there are? Or would you say, we elect not to?
Yeah, of course, Your Honor. I would, the language, I don't believe there are. That shows that counsel believes that there are no lesser included offenses. And I was trying to respond to Justice Bertani's previous question to the state, whether it would make a difference if Mr. Evans had agreed to this strategy. My answer to that would be no. And the reason was because that decision that Mr. Evans would have made couldn't be regarded as an informed decision when it was based upon advice that he's received from counsel that there are no lesser included offenses. So at that point, what is Mr. Evans supposed to do when his trial counsel is saying there are no lesser included offenses here? He's left at that point to follow up. And in regards to.
Well, that's fair speculation of a conversation, right, between the defendant and his counsel.
Well, I mean, going on that trial counsel stated that he did have a conversation with Mr. Evans.
Yes, but that's the answer, yes, to the court. Yeah, I did have a conversation.
But the substance of that conversation that trial counsel would have had, and he's saying that he did.
Definitely, we don't know that.
We don't know.
That's speculation.
It is, but
What's on the record is, yes, answer to, I did speak to my client, and then the comma, so to speak, I don't believe. That's on the record.
correct, yes, absolutely.
And how else could you interpret it, I suppose, other than non-awareness?
That's a defensive position.
That's what I thought, yeah, if you were
That-
your position.
That the conversation, even if he had a conversation with Mr. Evans, the advice that the trial counsel would have gave to Mr. Evans would have been incorrect. Based upon his statement, I don't believe there are any lesser included.
You need to even go to that speculation.
We don't need to, Your Honor. It's just, I was trying to answer Justice Bertani's
Oh, I'm
question to the
sorry.
state.
Well, that's okay. I got the answer.
I believe time is up, Your Honor.
Okay.
No questions.
Further questions?
None further from me.
We have no further questions from the bench.
Thank you, Your Honor.
Time is up.
Thank you, sir. Thank you,
counsel.
sir, as well.
Well, thank you, counsel, both for your fine arguments in this matter this afternoon. It will be taken under advisement by this court, and the court will issue a written decision. At this time, the court is adjourned for the day.
Thank you.